I'll just start by saying hi to everyone and thank you for joining us for our Good Grief workshop. Good Grief is an all-in-one platform that supports people navigating caregiving, end-of-life planning, and loss. And we do so by providing helpful guides, checklists, workshops like these, connecting you with vetted experts, and a supportive community of other people who have been in your shoes and know how to help. I'm Veronica Polito. I'm the founder of Good Grief, and I'm really glad you're here, especially for our Estate Planning 101 session. Today's session is led by Adrian Resendez. He's a licensed attorney here in Austin, and he's a partner at Bruff and Resendez. Adrian and his firm practice in the areas of estate planning, probate, and guardianship. And they also support clients across areas like business law, intellectual property, and immigration. I've had the great fortune of getting to know Adrian through the work we're doing here at Good Grief, and he's been incredibly generous with his time and expertise. But above all, what has really stood out to me about Adrian is just how deeply he cares about the people he works with. He really is one of the good ones, and he's consistently going above and beyond to make sure families truly understand their options and that you feel confident in the decisions they're making. So I'm really excited that he's here with us. Uh, Estate planning topics like wills, trust, probate, they can feel very confusing and intimidating, especially if you haven't navigated them before. I know that for me, this was a lot of topics I hadn't heard about before we went through the loss of my dad. So, Adrian is here today to really help bring clarity to these complex topics and explain to us what they really mean in plain language so that you can truly feel more prepared to plan ahead for yourself or for your family. So we're really lucky to have him with us today. Really quick before I hand it over to Adrian, just a note on the format for this session. The workshop will be about 30 minutes long and it will be followed by a Q&A. So what we'll do is if you happen to have any questions that come up during this session, you're more than welcome to pop them in the chat so that you don't forget them, and we'll be sure to address them at the end. Part of the reason we're leaving them to the end is that at the end of the call, we will pause the recording. We're currently recording because this is such an important topic, and so that members who couldn't join can listen back. But when we do pause, you will have free reins to ask questions and do so in a way where we're protecting your privacy. So with that, Adrian, I will hand it over to you, and thank you so much for being here.
Thanks for that awesome introduction. Let me, as I'm gazing off to the side, bear with me. I'm gonna do share screen so I can share my presentation. All right, everybody see that okay? We're good to go? All right. So I would say, 101 when we try to do the basics of anything. But of course, if y'all have questions that go beyond 101, happy to. I cannot really give anybody specific legal advice, but we'll go over some things, and I'm happy to maybe give some scenarios in answering some questions at the end that'll be helpful. So try my best to address whatever's asked. So the most frequent question I get when people reach out is, what documents do I need? And it always comes down to what documents are valid during somebody's lifetime versus when they pass away. And we kind of put all those documents, both while you're living and after you pass, into one general term called estate plan. An estate plan, and we call it estate planning law. And of course, it can contain various documents, and every situation is different. Yes, there's your typical, married couple with children, all from the same marriage, and those tend to be similar. But certain assets can change things as well. We'll get into that a little bit. It's very important to note, and I always get this question, well, I had power of attorney, or, they had power of attorney for somebody. Yeah, I'm very worried about that, or can that person access things? And it's important to note that a power of attorney will extinguish upon somebody's death. So that's one of those documents that It's really good while the person's living, but goes away immediately upon their passing. And then a will, on the other hand, only goes into effect after death, but can generally be changed up until death. Now, there are certain scenarios where it can't be changed or shouldn't be changed. Most of the time, when someone's no longer in the mental capacity to do so, we'll get into that a little bit as well. So, here's an example of some of these estate planning documents that are during your lifetime and they extinguish upon death. So, two types, and for the most part today, I'm going to be talking about Texas specific examples because that's where I'm licensed. I know other states have similar documents. I would just say if you are a resident of a state other than Texas, you're going to want to check for the equivalent or consult with an attorney in that state or licensed in that state. Those power of attorneys here in Texas are generally a durable, which we also call statutory. What that means is everything that isn't medical, I usually say. So, and you can be specific. There's a long list on the actual document, and usually there is a space to indicate that you are choosing to give that person power of attorney or multiple people power of attorney over your business affairs, your ability to do stocks and bond purchases, and things like that. Whereas the medical is going to be certain choices of care. Now, there is a limit to that. I don't know how old everybody is, but but there was a famous case about a woman named Terry Schiavo who became incapacitated, and there was a fight between her husband and her parents over the treatment that she got medically and that sort of thing. And that's actually where the last document listed here comes into play more, which is directive to physicians. And that is more about what type of treatment you would want should you be on. Uh, I usually say close to death within 6 months or something similar. But you're able to indicate some of those things on these documents. That way, you're not putting the person or the people that you're designating in a position to make tough choices. You've already kind of said your intent. It's already a pretty tough time and it's very emotional. So it's always better to put more there about your specific wishes. Declaration of guardianship is a separate document because a guardianship, at least in Texas, is established through the court. The reason why is because we are taking away someone's rights, and these are rights like the right to vote, the right to marry, the right to carry a firearm, rights that we think are kind of fundamental rights. And because they're so extraordinary, it needs a judge's ruling. However, you can declare who you would want to serve as guardian, and as long as they are still fit and willing to do so, God forbid, but you get in that position, they would be first choice. The court is always going to pick what's in the best interest of the person, but that also helps the court know before you lost your capacity to choose, that was the person again or people that you decided. And then the HIPAA release, that's a little bit newer, and that can list as many people as you want, the ability to access your health information from a provider. The rules are very strict on what information can be shared. So this helps third parties like those doctors, like hospitals, to be able to release that information. And you can have those actually, some of these on file with your primary care physician. And then also, you always want to keep digital and physical copies. So then, what is a will? If those are all documents that are valid during your lifetime, uh, what's the purpose of a will and when does that come into effect? So that's a legal document. It outlines how you want your property distributed, and then it also allows you to identify beneficiaries and also nominate who would be the guardian of any minor children or actually heirs. So let's say you decide to leave certain things to your grandchildren, but you don't want a 16-year-old getting a windfall of money. You can actually say who would be in charge of that money until a certain age. Again, each state has different laws, but we'll use Texas as an example. It's really important. So, certain states are what we call community property states. What that means is that there is a presumption that anything you acquire after you get married is both you and your partner or spouse's. That is, there are some exceptions like inheritance from your own family or from someone else, but generally, we're a community property state. So if you have separate property, but you don't want necessarily your spouse to get all that, maybe you have children from a prior relationship or just somebody who you want to leave something to, that is your separate property, you can do that easily through a will. So you can see they can get more lengthy and more complicated than just the simple, I'm leaving everything that I have to my kids, which, I hear a lot, which I understand. So, there are actually really no restrictions who you leave your property to. Actually, there's quite a bit of people who are including pet trusts in their wills as well. So you can do that. Of course, the pets can't really decide. So it'd be similar to leaving it to a minor. You'd have somebody in charge of that. I've had a few of my even close personal friends say, well, I'm just gonna go ahead, type out on my computer what I want to happen to all my stuff when I pass. And I'm just gonna save it to my desktop. Well, there's a couple problems with that, but just to be clear, not a valid will. And then there are some states that allow for video recordings. I'm trying to remember. I think it was like something as silly as like the Mighty Ducks, like the third one where there was a video will and they're explaining, I want them to have this and them to have that and all that, right? Well, that's not valid in Texas. Now, it can be something you can include on the side to kind of maybe explain why you left to who or who you excluded, but that cannot be presented for a will in a court. So I don't know if people have heard this term, but we call it intestacy. Intestacy, it's a legal term, and that means to pass away without a will or some type of binding declaration. That means you have some asset that either you forgot to designate a beneficiary or you did not create a will that was valid, and so it's left to the state's basic rules and laws who gets it. And so each state has different ways that they interpret that. But most of the case is, if you're married to your spouse, if you have children to them and your spouse, if you don't have children, if you don't have a spouse, it goes either up to your parents or to your siblings. Now, you might have a certain way you feel about your parents or your siblings or, well, some of your kids are it's I've seen every variation, right? So unless you want the default rules to apply, you should absolutely specify those things, right? And then where I see it gets most complicated, and if you're on this call and you have children from a previous relationship to the one that you're in now, or you have children for multiple partners or spouses, you are the poster child for needing a will. Everybody needs one, but that is like when it's most important and where I see the most fights over houses and property and accounts. So we call it an estate plan also because we're planning for the inevitable. We all have to pass away one day, but we don't ever like to think about it. But we don't get to really choose when that happens for the most part, right? At least not in Texas. So we plan to avoid probate. Probate is going to the courthouse in the county that you have resided in the last 6 months before you pass, which is an interesting thing because people tend to move to retirement homes or nursing homes that may be different counties than where their family is. Well, their family is going to have to go to the county they resided in the last at least 6 months when they passed. So that's something to keep in mind as well, especially when you're moving a loved one or some of those things that are more practical. And so, again, we want to plan to avoid having to go to court because court is expensive. Really, the only people that make money out of court is who? The lawyers. And I'm a lawyer telling you that, right? So let's avoid that if we can. So what I tell people is when they first reach out to us for this type of plan, I say, well, what do you have? What do you own? Make an inventory. And then the first thing you want to do is see all your accounts. And you want to make sure they either have co-owners, beneficiaries, or somebody that is paid upon your death if you don't want them to have access to it during your life. The other one, which is more and more needed every day, is passwords and data. I've had several people who either they got in an accident, they went into for a dental procedure, and they didn't pass yet, but they were incapacitated. Well, just so happens they're a small business owner, or they are the payroll person that only has certain passwords. So make sure somebody has a way to access those passwords or crucial data needed that if you weren't there, things could still get done. Business could still get done. So I use the Apple example because it used to be that I would have to go to the court and I would have to, you probably heard this word, a lot of, I know Suits is super popular and things, subpoena. So subpoena is asking a third party not involved in a court procedure to either appear or produce something. So we used to have to go subpoena Apple for access to somebody's photos or documents or data on their iPhone. Now, and everybody on an iPhone, you can go to your settings right now and you can type in legacy contact. You can start typing that and it'll pop up and it's in your settings. And you can actually designate a contact who can then, when you pass, access that information. I apologize, I'm not an Android person, but I believe there's something similar on that as well. For businesses as well, you also want to make sure you have an operating agreement. There's several reasons for that. Veronica mentioned we practice business law as well. Even if you are the sole owner of a business and it seems kind of silly or awkward to make an operating agreement with yourself, you definitely want to do so because you want to designate who you would want either to take over the business or be able to sell the business. And most businesses have, bank accounts and those type of things, or some value through an appraisal. So it would be who would get that when you pass. And I always tell people operating agreements are if X happens, if I get divorced, if I become incapacitated, if I pass, who gets what, who can do what. So very important. And then for property, when I say property, I mean real estate, and we call it real property. You want to look at, there's different kinds of deeds in Texas. One of them is named after a former first lady. It's called a ladybird deed. Some people also call the town lake Ladybird Lake. So same lady. And that is essentially, I want somebody to have my home, but for my life, I get to continue to live there as long as I'm living. And then there's something called the transfer on death deed, and we'll get to that in a little bit more detail. So again, downsides, get a little bit more specific. Most attorneys in Austin will ask for a retainer. Some are flat fee. And you can either come out better with flat fee or worse. And when I say you, I mean I also have done this same presentation for attorneys, right? So this would be the other way around, right? You either come out better or worse with flat fee or hourly, but usually you have to put some type of money down because it's billed hourly. And it can be a long and drawn out process. Sometimes it can take years, depending on what the assets are. So, what does that mean? More time, more money, more cost. And also, you're not able to easily just move on with your life, right? So it just kind of lingers there. It's not fun for anybody, right? So we want to do an estate plan to avoid that. And then let's say that you have to open a probate and we call it then opening an estate, and you didn't have a will, there's a neutral attorney, and they're known as ad litem attorneys. They could get appointed and then you actually, your family members and your heirs will actually have to pay two attorneys to figure out who was supposed to be the heir. And that's what the job is. That attorney is appointed to make sure that the heirs are who the person applying to be administrator or to probate the will, to make sure they're telling the truth, right? These are actually all the kids that they had. They were actually married to this person. Common law marriage, I don't want to get too much into the weeds here, but just so you know, it's not something you can necessarily just say or assume. Some counties allow for you to file for, it's called an informal marriage. But a common law marriage in the state of Texas has to be proven by a judge. I have myself been in legal battles trying to prove that there was a common law marriage. And at the end of the day, it's the judge that decides based on factors. And unfortunately, one of the most crucial witnesses is no longer with us, right? So it makes it very difficult. Again, you're at the mercy of the judge in the court. Every judge is a little bit different. They have good days, they have bad days. I always tell my clients that before we go in, just follow my lead, read the room, be respectful, but you never know, right? And then if you open a probate, sometimes you're opening up for a dispute. So because you open it, some of those things that I was saying, like the neutral attorney will have to investigate, speak with people. Well, all of a sudden, people start to think, hey, maybe I can get a piece of that, right? And so it opens the door for people to possibly come in and claim they're an heir, costing everybody more money, costing more stress, more time. So you can see there's some downsides for sure of probate. Here is an example of if somebody were to pass away without a will. So if you look across the top, it's this specifically, and there's charts for a couple different scenarios, but this is for married people with children. And if you notice, it separates personal property from real property. So personal property is treated differently than real estate. And so you'll notice, there's a scenario where there's some interesting shapes there, right? For us 90s kids, those look like some 90s shapes, right? So the one, it's kind of pretty simple, right? A third to the surviving spouse and two-thirds to the children. But you notice on the real property, it's kind of like a triangle in the middle of this circle. And so the surviving spouse essentially gets to stay in the home, the primary home, for their life. And then the children all split equally, but they have to be subject to that surviving spouse living there. So the common scenario I see is the kids are upset because they didn't like stepmom, they didn't like stepdad, they don't get along. Well, unfortunately for them, they can't do anything as long as step parent lives. Now, you can imagine a scenario where a parent is elderly and then decides to marry somebody 20 years, 30 years younger than them. Well, that life estate all of a sudden becomes a lot longer, right? So I see a lot of frustration with that. And then at the bottom, you'll see that all of the community property goes to that surviving spouse. Again, could be a stepfather, stepmother, or the share. goes all to the children, and then there's some specifics there. But um, because we're a community property state, right, we wrote our laws to make sure we protected the surviving spouse and then children. But again, sometimes that surviving spouse might not be the parent of the children because we would say, well, of course, the surviving spouse. But think about a scenario where the surviving spouse then remarries somebody else. And you see it starts kind of spiraling there. And we'll get to that, to solutions to that in a little bit as well. We're going to go back to wills and kind of talk a little bit more about what a valid will is. So, the types that are acceptable, we get all our law, they're condensed into what we call the estates code. And the estates code here says that it has to be in writing, it has to be signed. The testator is the person making the will in person or another person on the behalf of the testator in the testator's presence and under their direction. And you notice that's kind of interesting, right? So imagine somebody, they are physically impaired, so they have to direct somebody else to actually, sign for them. But that's why number three comes in and it's attested by two or more credible witnesses. And this one's always interesting to me. And it's the only time I've seen in law where somebody has to be this age, but both witnesses have to be 14 years or older. Where did that come from? Why? I have no idea, but it's 14 years old. And then they actually have to sign, and then we do what's called a self-proving affidavit at our office. It's not necessarily required for a valid will, but it actually, if we end up having to go to probate, it makes things a lot easier and cheaper. It's a notary saying, I witnessed this person or somebody at their direction, and these two witnesses, and they all sign my notary book. And it's just kind of like one more reassurance that everybody was on board, they witnessed it, it all was good to go. Now, they do actually accept holographic wills. And no, again, 90s kids, it's not like a holographic Pokemon card. No, this is different. Holographic is in somebody's whole handwriting. Now, it's not required to be attested. I kind of gave you the condensed version. There's certain other things that need to happen. You need to date it, you need to sign it. But essentially, if everything is written in your own handwriting. Now, people ask me all the time, what if I type out the whole thing and then sign it? There's been a lot of case law. I tell people, don't do that. Write the whole thing out in your writing because what you don't want is somebody typed up a whole thing and then, put your incorrect or forged your signature, right? The reason why is because, yes, sometimes we have to consult with handwriting experts. And the more handwriting we have on the document, the easier it is to prove that. What does a typical will include? So who you are, your name. I'm married to X. I have X amount of children. They were born to me or adopted by me. You even want to put if you were previously married or you had children predecease you. And then the executor would be so we call it an executor on the will, but then if they actually get appointed by the court, it's called an administrator. Those are usually the same person unless the executor cannot serve for whatever reason. They passed away, they lost their capacity. So you at least want to name one other. I also tell people try to name an executor that's at least your age or younger, not older, obvious reasons. Um, if you have minor children, you want to say who you trust to be their guardian and be their trustee. Now, somebody who's guardian of your children, meaning the person who's going to take them into their home or physically take care of them, may not be the same person you want managing their money. So sometimes you can separate that. And then beneficiaries. So these are my children. I leave everything to this child and this child. I leave nothing to this child. I have seen that before. I actually warn against leaving nothing to someone. Instead, I say if your intention is that they get nothing, leave them at least $1. And the reason why is because at least they're gonna have to get served if there's certain problems and things like that. They'll likely become aware that you've passed, and that kind of signals I was very intentional about what they got. Okay, and then obviously who you don't want to benefit goes to that, but again, the dollar. You're going to want those witnesses. We learned you want two of them, at least 14 years old each. You probably don't want to use a beneficiary. In fact, don't use a beneficiary as a witness or a notary. Again, those aren't needed as long as the whole will is in your handwriting. But obviously, if it's not done formally, if it's not done with the notary, if it's not done with witnesses, somebody who's not happy about getting their dollar can make way bigger of issues because of that. You can actually create as many wills as you want during your life, but you have to be of sound mind. That's from the estates code. That means you have to have capacity. Now, capacity is on a spectrum, right? And what I usually tell people is the test is, do you know what you own? Do you know who your heirs are? And do you know which heirs are to receive what? That usually proves capacity, even if somebody has or starts losing certain types of memory, or dementia starts creeping in, and those type of things. Remember that the power of attorney is extinguished upon death. So anybody who held one immediately when that person passes away should not be using that. In fact, if they do, there could be criminal implications for that. And then a will is only used again after death, probated, submitted to a court. A judge is going to declare if it's valid or not. And then the person named as executor usually is the one to bring it to the court. And that's not necessarily who is the beneficiary. Those can be multiple people. And then actually, it's very important to know where the original will is. Yes, you can probate a copy, but it's a lot harder because you have to prove that it is the only copy of the original. Because remember, you can create as many as you want. Who's to say you didn't go create another original one that is more valid or more recent in time than the copy you're trying to? So they actually appoint that neutral attorney ad litem when there's a copy of a will. And that person is attorney is to determine if that is indeed the copy of the most recent will. And there are plenty of fights about that as well. Again, why even have one? Well, it makes clear your intentions. You're really setting things out so it avoids conflicts. I've heard people say, "Well, it doesn't matter. I'm no longer here. They can deal with it." Well, okay. All it takes is for you to go through that in your life, and you'll realize how important it is. In fact, I get a lot of people calling our office. I just went through this with my siblings or my father's estate, my mother's estate. I don't want that to happen to my children. Um, of course, you don't have to share it with anyone. And then I recommend that at least the executor knows and knows where the original is. And then it's very important to keep that original in a safe place. It's again more expensive, more complicated to prove that original was not revoked. Also, dealing with death is not fun. So this helps your family stay organized in a difficult time. You're telling them your wishes, so there's no debate. Well, he told me this, she told me that. Doesn't matter what they told you. What is in the will, right? And have I seen people put things in wills that are different than what they told? Yes, absolutely. And then, of course, your minor children and your money, which then becomes their money. Like, who do you want to be in charge of that? It better be somebody you trust and not who the court doesn't even know. They appear out of nowhere and they decide, yeah, I should be the one in charge of your children. And I always tell people, imagine your least favorite sibling or family member, and now all of a sudden they're in charge of your kids and raising them, right? So it also makes the court procedure more straightforward, and it helps change properties over. And if you plan accordingly, right, you should have those beneficiaries on everything. But some people forget, or you created an account. You didn't have time to put a beneficiary. You didn't have time to put a payable on death. I want everybody to leave with at least this. Check every account you have and check to see if there's a beneficiary or payable on death. Even you're checking your savings at Wells Fargo, at Chase, at all those big banks. I don't know why they don't tell people this for the most part, but you can go in and you can designate these things. It will make a huge difference. And then also the will can help your family access information from your accounts. These are, data, photos, things that are not able to be replaced. Yeah, you can replace money, even though people don't believe that. But yeah, you can, right? That photo memory of some event that was only on that person's phone, no, right? So again, if you forgot to do that legacy contact setting that I brought up earlier, your family members can probate your will to access those certain things. It also tells third parties like banks what your desires are and avoids family members or even the state. Yeah, the state of Texas getting all your property. All right. Who wants that? Not me. Okay. And then blended families, Brady Bunch families is what I call them sometimes. It's, making sure your children are protected no matter how many times you got married or who you were married to when you passed. And then trusts. So I would say it's about 50-50 people reach out and they say, I need a trust. And I am happy to make trusts for people, but they're usually a lot more expensive, more involved than a will and an estate plan. And really, when you get a trust, you should also get a will. We call them pour over wills. And what that is that if you forgot to put something in your trust, the will designate everything to pour over into your trust. Okay. Again, every state has different laws. There's different types of trusts, but some are revocable and some are irrevocable. So in that Brady Bunch scenario, let's say you told your spouse, hey, make sure to take care of my children from my previous marriage. It could be that you, of course, trust that person with your life. Obviously, you married them, you have love, affection, but that's not their blood child. And maybe they raised them, maybe they didn't. But unfortunately, I see this all the time. You have no guarantee that that relationship is going to continue to be a good one or positive. You also have no guarantee that your spouse is not going to marry somebody else after you pass. So a irrevocable trust will help with that scenario where you put in what you want to and your spouse will benefit for their life, but should they remarry, should they, try to do certain things, that trust is irrevocable. They cannot just, liquidate it and go take all the money. No, it's going to make sure that your children are taken care of, even though you're no longer here. So you don't have to probate as long as everything that you had was in that trust. So it's awesome. It avoids probate. And it also is a protective mechanism for all the what ifs and all the scenarios that can happen. Again, a lot of people don't really understand it. I think Chat GPT loves trust because I keep getting people, hey, I asked Chat GPT, what should I do? I should do a trust. I'm like, you don't need to do all that, right? And I will talk people out of spending more money than they have to. I'm one of those lawyers. I can honestly tell you all that. And again, it tends to just be overkill for a lot of people. But the trickiest part, and this is where they fail the most, is, this one pains me. And I don't know who to blame, so I'm just going to say it this way. A trust is only as good as what you put into it. So you can actually designate, as long as your bank allows, the beneficiary of those checking accounts to be a trust. So then it would automatically go into the trust. You can have an account, checking, investment, whatever, that the trust is an owner of. So those would be things that in the trust. You can deed your real estate into a trust. But let's say you sell that and you buy a new piece and you forgot to put it in the trust or you don't do it. The trust is only as good as what you put into it. Again, so you have to make sure there's a lot of maintenance for trust. You're going to file tax returns as well. So it ends up being a lot more work than a will, but again, it avoids probate. So every scenario is a little bit different. I didn't go through the exhaustive list, but you have to be careful because it's always good. I call wills actually Plan Z. So if you do an estate plan correctly, you set up all your beneficiaries, you even make a trust, you're good. But if anything wasn't designated, wasn't put into the trust, you didn't take care of, that power of attorney is gone as soon as you pass, then you want that Plan Z pour over will to go everything into your trust or just a will that your family unfortunately has to pay a lawyer, but goes to court and probates. So, um, again, all bold, designate those beneficiaries, keep updated lists of accounts. Every time you open an account, try to remember, does my will cover this? Do I need to put it in the trust? Does it have, a beneficiary? And the last little nugget, I love this. This is Texas specific. Other states have something similar. There's something called the transfer on death deed. So usually the most valuable piece of property somebody has is their home. And you can actually, especially if you're not married, if you are married, you can transfer on death deed to each other and then to somebody else. But if you're not married and you're single, you don't have kids, maybe your parents aren't living with, you can designate a first beneficiary and alternatives on a transfer on death deed. I actually left out a word. We call them TODs for short, but in Texas, we call them revocable transfer on death deeds. Meaning, if you decide to, in a transfer on death deed, leave a piece of property to whoever you designate, but you need to sell your home for whatever reason, you can revoke it. It gets ignored by the title company and sell it. Just remember, you have to do it every single property you own, real estate, and it has to be recorded in the deed records. There's a lot of laws concerning deeds. The most important for a transfer on death deed is it has to be recorded in at least some county, but you would want the county where the property is. So that one is also one of those things. If you take a nugget out of here, you own a house, look at the transfer on death deed. It's awesome. And yeah, that's my contact info, and we can open up for questions.
Adrian, first off, thank you so much. That was such valuable information. I'll be sure to share Adrian's contact info in the video notes in case anyone is interested. Thank you all for joining our session. I really hope it was valuable.